Thank you very much.
SJC-11395, William Sheehan v. David B. Weaver et al.
Yeah.
All right, let's proceed. Good morning.
Good morning, Your Honor. My name is Peter Kober. I represent the appellants in this case, David and Jean Weaver. The issue before the court this morning is whether the housing court erred in ruling that Chapter 143, Section 51 of the general laws was applicable in a case that did not involve a violation of the Massachusetts Building Code, which related to escape from fire, and in a case that involved a structure which consisted of 3 residences and a chiropractor's office, in which the chiropractor's office was physically remote from and was not used as that part of the building that was in violation of the building code. Specifically, we're talking about a stairway and a porch that serviced only 2 of the 3 residences and did not service the chiropractor's
Could you
office.
clarify, when you say service, there was no access at all from the chiropractor's back door onto that porch? Say,
Well,
if it needed to have access
The
through a second means?
the way the building was set up was the chiropractor's office was in the front of the building,
Correct.
and the stairway was on the side of the building.
Okay.
And so in order to access the chiropractor's office, it was not necessary to use that particular
I
stairway.
don't mean necessary. Was it available to anyone in the chiropractor's office to access the porch and from?
Is that where the mailbox was?
Well, the mailboxes were actually below the stairway.
So they had to
that
go
the-
on.
The individuals who were working in the chiropractor's office could go to the mailbox without going up the stairs. And indeed, one of the 3 residents, did not need to use that stairway either.
You're still using need to use. I understand it.
Could use it, certainly.
And available to use from their own access point?
I'm not sure.
It was outside, and everybody used it from the outside, right?
Well, if you wanted to go into the chiropractor's office, you would not use that stairway. If you wanted to go to one of the 2 residences, you would use it. Am I not answering your question?
But that's okay. Thank you. I don't
So,
want to
so
belabor it.
is it your view that the chiropractor's office is a building, but that part of the building, which is a stairway, is not a building?
Well, that's actually a very good question. And I think you need to look at what is the prominent or predominant use of the entire structure. And the predominant use of the structure really was the 3 residences as opposed to the chiropractor's office.
How do you determine that? Just by counting? So if you'd had, as I take it, the first floor was the chiropractor's office and also one of the residential units, is that right?
I believe there were 2 residential units, I think, on the 2nd floor.
Oh,
and a
2 on the
third one
second floor.
on the 3rd floor. There was no residential unit
Okay.
on the ground floor where the
So
chiropractor's
if you'd
office.
had 2 commercial units and 2 residential units, then how do you determine whether or not it is what's the predominant use of the entire structure?
Well, that's a harder case, obviously. And again, I think what you need to look at perhaps is the number of people who are, using the building. In this particular instance, we had a chiropractor's office as opposed to a restaurant or a supermarket or something of that nature. And I think that would be something that would more closely fall in the type of quote-unquote building that was being contemplated by the statute.
I
in
guess I
terms
just
of
don't
its commercial-
understand sort of the criteria to be used. If, you could easily change this into something where you had a supermarket which had tremendous numbers of people coming in and out, with a CVS next to it, and then having 10 residential units on top of that. it's a mixed-use structure. How do you determine whether the building is or is not predominantly a building for the purposes
Well,
of?
and unfortunately, and I don't mean to dodge your question, but I think it literally is case by case. And if you have, for example, 10 floors, if you're talking about a larger type of operation like Rose Wharf or Charles River Park or something of that nature, then I think you are more closely approaching what the legislature had in mind, perhaps, when they used the word building in Section 51.
True that our cases, at least to date, when they have exempted what and said 51 doesn't apply, there has been, it isn't just residence, it's the fact that the owner was one of the residents, correct?
Correct. In
I mean, this was always an investment for your clients,
correct.
the whole building.
Correct. And certainly, excuse me, all of the cases that have been decided by the Supreme Judicial Court or by the Massachusetts Appeals Court have involved that type of a situation. The one exception was the Glidden versus Maglio case, in which there was a 3-family residence, which was not owner-occupied. And in that particular case, the trial court had determined that that was not a building. When the SJC considered it, however, it determined that it could decide the issue based upon lack of causation, and so never actually reached the issue of whether it was a building in that context.
Does the legislative history shed any light on what the legislature envisioned?
Well, that's a question that I think we've all scratched our heads about as we've been trying to look at this. Certainly, the legislative history of this particular statute, as it was written in 1972, suggests that what the legislature really had in mind was creating a unified code to facilitate code approval and code enforcement in such a way as to encourage the construction industry in Massachusetts. And I've included a copy of the report to the legislature as an addendum to our brief. The more difficult question is whether there was any specific intent evidenced by the language of the legislation, which would suggest that that the legislature intended to rewrite the statute so as to eliminate the concern that had really been driving the focus of the statute up to that point, which was escape from fire, or whether the legislature intended to effectively turn every type of tort case involving a building code violation into strict liability.
But it changed the language.
Well, it changed the language, certainly by deleting the sections 21, 24 to 28, and 30 that had related to fire concerns.
When did it do that?
I'm sorry?
When?
1972.
72.
Correct.
So are we to infer from that that the legislature was more concerned about users, about people who were using property commercially versus people who were using property residentially?
In the earlier versions, what the legislation related to and what they were doing typically was they were referring to other sections of Chapter 143.
As to what building meant, you mean?
Well, not necessarily. That's part of the difficulty. But what they were referring to, for example, in the 1882 version, they were talking about tenements, apartment buildings, or boarding houses where there were more than 4 families. In 1894, and 1913, they were talking about residences involving more than 10 people. And so the legislation was not necessarily limited to only commercial buildings. It could be applied to tenements or apartment buildings that had a certain number of people. And the way this court had interpreted that statute, though, in the Rapucci case, was that it was applicable to a plaintiff who was trying to escape from fire. And in the Festa case, which was decided in 1969, SJC specifically limited it to individuals who were injured when they were trying to escape from fire.
That's pre-72.
That is pre-72, that's correct.
So if you had a 3-unit building and it were zoned in such a way that the occupant of each unit could operate a profession out of his apartment, and on the first floor you had a chiropractor who took in clients into his apartment and serviced the clients, provided service to the clients. On the second floor, you had an accountant who did a similar thing, and on the third floor, you had a lawyer who did a similar thing. Would this law apply? Would it, and who would it apply to? Would it apply to just those who were visiting, the lawyer, the accountant, and the chiropractor for commercial purposes, or would it apply to anybody who was using the building?
In other words, would it apply to a guest
Yeah.
as opposed to a business invitee? Well, certainly in the scenario that you're positing for me, that sounds more like a commercial application, notwithstanding that the individuals who are the professionals are also living there. Because certainly by virtue of the fact that for however many hours a week they are opening their homes to the public, that would certainly seem to be more of a commercial use.
Is a 200-room hotel a building under this statute?
Hotels traditionally had been dealt with separately. They'd been specifically referred to in some of these earlier cases. And I would certainly submit that a hotel is more akin to a commercial application than to a residence. Again, bearing in mind the number of individuals who are going to be accessing and egressing from that building. So I think a hotel would be more clearly falling within the category of a commercial enterprise. Part of the, I'm sorry.
You go ahead.
All right. Part of the difficulty with the statute, of course, is that the word building is a general word which is put at the end of a series of specific terms. And one of the principal constructs of legislative interpretation is that the court needs to follow the doctrines, and I apologize for my Latin, Iustum generis and nocitur associus. What the court needs to do is look at the general term in the context of the specific terms
And frankly,
that precede it.
if building means simply anything, then all of the things that go before it are really unnecessary.
They're completely superfluous.
Completely
And
superfluous.
this court has said as much in the Eakin case. The other interpretation which the court specifically gave to it, albeit I would say in dicta, in the Benucci case, was it said that the word manufacturing, which appears before the word establishment, actually modifies both the word establishment and building. So
Said
what they're talking
It didn't
about.
actually answer the question, right?
Sorry?
It didn't actually, the court didn't actually answer the question.
Correct, correct. But it simply said that interpretation was consistent with the result that it was reaching in that case.
Now, if it is not a building under Section 51, does the building code apply?
If it is not a building under Section 51, it is not a building as to which strict liability would apply. The building code certainly still could apply in the sense that there are other provisions of the building code, and my brother has actually referenced those in his brief, with respect to dwellings and apartments and things of that nature. And the word building actually is interspersed.
And the fact that the building was built in 1909 and the code didn't come into existence until much later than that doesn't matter, is that right?
Well, certainly as far as the expert who testified for the defendants was concerned, he said that the building code really shouldn't apply at all anyway, because this particular building preceded it, and as far as the stairwell was concerned, it shouldn't be subject to those particular requirements that were set forth in the building code.
When you say it shouldn't apply, it can still apply, I take it, as evidence of negligence.
Absolutely, absolutely. And that was never in doubt in this particular case, and I think the jury was instructed with respect to that, and the jury found ultimately that the two defendants were 60% negligent.
Counsel, your time is up.
My time is up. Thank you very much.
May it please the court, my name is Louis J. Muggio, and I represent William Sheehan. It's noteworthy that the trial court, in denying the defendant's post-trial motions, rather than issuing a marginal notation denied, which we often see, took great pains to write, I would describe as a scholarly 17-page opinion, dealing with issues which have not been fully addressed by either the appeals court or this court. The appellants essentially make two arguments. The first argument I could touch on briefly is whether the fleeing from fire requirement that was in prior versions of the statute applied to the statute in effect at the time of this loss. Trial court, citing Judge Gantz's decision in a trial court case, basically said something very simply, that we look at the very plain language of the statute. The statute in effect at the time of this loss was 1972 statute when the state building code was put in effect. At that time, the fleeing from the fire requirement was removed. The statute was amended 2 more times following the 2 Pendergast cases. In both of those revisions, the legislatures did not, again, import the fleeing from fire argument. My brother's briefs and the amicus briefs in this case go on at length about rules of statutory construction. The primary rule of statutory construction is that when we read a statute, we look at the words and we give the plain meaning to the statute. Simply put, there was nothing in the statute that was in effect at the time of Mr. Sheehan's injury that required him to be fleeing from fire. So on that issue, I suggest that the trial court was correct, and what he did is he looked at the statute. Having determined that this court's footnote in McAllister, which is where this issue, yes, Your Honor.
No, it's just that the building issue is much harder, don't you think?
I'm going to get to that. Okay. Now, in what the analysis is, contrary to what the appellants and the amicus argue, in determining whether a building is a building under Section 51 for strict liability purposes, there is language in the building, but the Benucci case from this court and the Orsono case from this court does not limit the building to those specific types of structures. Moreover, what they teach us is that if a building is public or commercial, and it's in the disjunctive, I believe, the language from Benucci, if a building is public or commercial in character, it qualifies as a building under Section 1 for strict liability.
Could I just,
You were referring, about to tell us about the footnote in McAllister.
Benucci, McAllister, or?
McAllister is about the fleeing from fire.
McAllister is the slip and fall case on snow and ice that was a post-1972 case. In McAllister, the plaintiff did not raise a strict liability count. He had counts for negligence, breach of implied warranty of habitability, breach of the covenant of quiet enjoyment, and another provision, another claim for breach of the lease. The strict liability issue was raised in a request for a jury instruction for strict liability. So it was not surprising that the trial court refused to give that instruction. As the trial court found, and as Justice Gantz found in Merloni, the language, what the court, SJC in the footnote did, is they used the appellant's language, imported into the 72 statute the requirement of fleeing for a fire. Unfortunately, the SJC relied upon 2 pre-1972 cases for that proposition. So what we're suggesting is that the approach taken by the trial court, again, following Justice Gantz's lead in Merloni, was the appropriate way to go.
But the legislature was fully aware of what we wrote in McAllister. The appeals court has followed it a number of times.
Once.
Okay. Why isn't that some evidence that the legislature was satisfied with that interpretation? That has become the gloss on the statute. And if the legislature thought we were wrong, why didn't they change the statute?
With all due respect, I'm not certain how the legislature follows every decision of this court, especially where it's an obscure footnote and what has been referred to by 3 eminent justices as dicta. Again, I guess we get back to the primary rules of statutory interpretation. The plain language of the statute does not say one must be fleeing for a fire. To suggest that it's imported is inconsistent with basic rules of statutory interpretation. Now, getting to the building issue, I suggest in determining whether a structure qualifies as a building under Section 51 for the imposition of strict liability, it's more of a qualitative, not a quantitative analysis. It's not relevant as to what the actual income was. The landlord could be a bad businessman, as Mr. Weaver was in this case. It's not the amount of foot traffic. It's whether the overall use of the structure is commercial or public.
Well, could I just ask you about that, though? I'm looking at these words in the statute: place of assembly, theater, special hall, public hall, factory, workshop, manufacturing establishment. All of them arguably suggest places that, yes, commercial, but more to the point, are large and hold a lot of people. And I don't know whether a chiropractor's office on the bottom floor of a building that has 3 apartments fits within that description.
Well, I think the footnote, it's the last footnote, the Osorno case helps us, because in the Osorno case, that dealt with workers who were injured from a non-attached scaffolding in a condominium complex. In the last footnote in Osorno, they talked about this, what I would describe as the qualitative analysis. Is the building involved in a commercial enterprise? Benucci talks about that. So the language from Orsano tells us that we're not limited by the specific structures described. Those are descriptive of structures which have a commercial or public character. And that's what I believe the evolving case law is instructive on. Again, in formulating his opinions and writing his decision, the trial court realized there was scant guidance. There was the footnote from Orsano, there was language from Benucci, there was language from Glidden, but no trial court or no appeals court in this court has not written a comprehensive analysis of the statute. So what we take from Benucci, what we take from some of the other cases, we don't suggest that strict liability applies to a single-family home.
So if someone owns but does not occupy himself a 3-family apartment building and rents it out, that's a commercial enterprise, and that's a building under Section 51.
I would suggest using a qualitative as opposed to, that's correct, it's a commercial enterprise. And I suggest that public policy favors that. If you are a real estate investor, you have allegedly, as the Weavers had in this case, the acumen to effectuate repairs which in this case could cause devastating injuries. That's the policy behind strict liability. That same policy should not apply, however, to a single-family home or a home that someone occupies. And where the case law, I see it evolving, is there's a distinction between private/residential, that's Glidden, that's Benucci, versus commercial/public. And in determining whether this particular structure had enough attributes to be commercial under 51, the trial court looked outside the Section 143 ambit. He determined that on Lantner versus Carson, that there are certain exemptions under 93A. This case, there would be liability under 93A. So what, in analyzing it, and I agree with my brother, you look at it on a case-by-case basis. And what the trial court did in this case, he found, as a matter of fact, that this was a mixed-use commercial building in a commercial environment, that the landlords were investors, they never lived there, and accordingly had the resources. So to
Can I ask you, did the judge, or I didn't see it in your briefs, but are there statutes in other states
there are, Your Honor.
that have a similar language that would be helpful in determining what could have been meant by this general word at the end of a bunch of specific things?
In my brief, I did a comparative jurisdiction analysis to try to give the court some guidance. And the New York and the New Jersey statutes have that distinction. If it is investment property,
But the statute is the one that makes the distinction, not the case law.
but unfortunately, I think we're here because this statute is not clear.
I guess I was asking if there was comparable statutes using, language like our statute.
The closest that I could find, and it's in my brief, is the New Jersey and New York statute. And the owner of the property is not liable to strict liability if he resides or if it's two dwellings.
But that's specifically laid out there in the
It is,
statute?
Your Honor. It is. And I don't know the New Jersey, but I did cite that in my brief.
Am I correct that the predecessor to the 1972 statute was the 1945 statute?
That's what I recall, Your Honor.
And that 45 statute says manufacturing establishment or building mentioned in and subject to sections 21, 24 to 28. So their building had a meaning.
Yes.
And then what the legislature did in 72 was knock off reference to those statutes. But the question, I guess, is, does the meaning of building remain essentially as it was with regard to those which had reference to those fire egress statutes?
21 to 24 and 28 are fire statute, right?
Yes, Your Honor. Well, I agree with some of what the appellants allege, that not every building comes within the ambit of 51 for strict liability purposes. Because if it did, then that's why the developing case law, as I see it, is establishing, the bright line I see it is private residential, you're not subject to the strict liability provisions of 51. When you move into the commercial public genre, and that's where, and again, I go back to public policy.
But couldn't that be the same building? You could have a three-family structure, say, in Dorchester, that is owner-occupied for 5 years. That owner sells it to somebody who has it for purely rental purposes. It's the very same building. And I think on your analysis, it changes from one to the other. Very same building.
I think that was, you asked that question, I think it would. Because what is the, it's not the physical structure per se, it's not the brick and mortar, but what is the building, what's the predominant use of the building? Is it being used, as in this case, for a commercial enterprise?
But isn't the use the same? I mean, if you have 3 units, each of which is being used for residential purposes, they remain residential purposes as the use?
Well, then it's not a commercial enterprise.
Well, okay, but it's the same building, used in exactly the same way for people to live in. And in one instance, it all depends on who owns it. And that's not the same thing as who uses it.
All depends on who lives there.
Well, if I would suggest that under the case law, when an owner lives in the building, there is a private element, which negates what and again, I'm setting up the residential, private verse, so it's,
So if you had 2 apartment buildings right next door to one another, one of them was a 3-decker and the other one had 6 units in it, and it was under common ownership, the same person owned both buildings. The owner lived in the 6-unit building. The 6-unit building would not be subject to strict liability under Section 51, but the 3-unit building next door would be subject to strict liability.
well, I think when we get, as far as I understand the case law, the exclusion for strict liability under current case law, and I think it's Benucci or some, limits it to 2 families. When we then get into income from 4 units, we then have to, again, defer. This is a finding that has to be made by the trial court. And I agree with my brother. It's something that's going to be made on a case-by-case basis. But I think the bright line, which will guide trial courts in the future, is the predominant use private residential. And again, in response to Your Honors, well, that has a private residential element because the owner's living in one of the 6. However, in determining whether this is an issue that gets to the jury under 51, perhaps in that case, it's a hybrid analysis. You might have to get into a quantitative analysis to find out how much income that owner is reaping. So, looks like my time is up.
Thank you.
Thank you, Your Honors.